Good morning. Oh, I'm so excited. So are there enough forms for everybody? Are we running out of forms? No? Let Kat know because she'll make some more copies. So we've got a copy of both the purchase contracts, the AAR version and the non-member MLS access, I believe is what it's called. We're going to get started here. This is a two-part series. This is going to be today and next Tuesday. We'll see timing wise how I am in about an hour and a half, how far I get, if I actually get where I hope I end up at the end of the disclosure section. We'll see if we can get that far. Bear with me with regard to my polls. We're going to see whether I can flip back and forth between poll questions or not. I do not have them printed out, so hopefully we'll be able to click through them properly. Jackie's looking at me going, oh, I know what she's talking about. I hate only having one screen. I got to figure this one out. So, all right. So again, we're going to go over the purchase contract and the forms that interact with it. I'm not necessarily going to show you all those forms. A couple of them I pulled out. I really wanted to start with the buyer broker and realized I could end up 45 minutes into the buyer broker, and then where would we be with the lovely purchase contracts? So we are starting with the purchase contracts. We'll next Tuesday hopefully bring in the buyer broker again. So again, the forms today I'm going to specifically talk about are the AAR purchase contract, the February, I put February 2025. Actually, I think that is actually a 2024 version. I don't think that actually changed. Non-member purchase contract is actually December of 2024. I saw later, and then the seller compensation addendum. Maybe I'll change that slide tonight. So there you go. All right. So if you are online, folks, does anybody here have the Zoom up on your screen? Are you able to do that, Jason? Can you jump on? Yeah. So I cannot see the chat. It's just not possible. I don't have enough spaces to open up the chat. I recommend you keep yourself on mute. If you do want to ask a question, you'll have to go unmute. I have asked somebody here to try to open up the chat to try and watch it for you, but I'm not going to guarantee that that's going to happen because we may get involved in the conversation. So don't worry about taking screenshots. I will be happy to share the slide deck with people. Those of you in the room, send me an email so I know that you want the slide deck, because I'm not going to send it to everybody, but I will send it to you. Those online, actually, I guess I didn't have you register because I don't usually have my Tuesday class registered. So everybody online, send me an email as well, melissa.schwartz@realty1group.com. And I will forward you the slide deck. There we go. So, all right. Well, we're going to try to see if I can do a poll. Now, I think I have to escape out of that. Let's see. Well, maybe I don't have to escape out of that. Hold on. We'll go back into slideshow. Let's see if I can do this. Where's polls? More? Yay! I'll have to go backwards here. All right, we're going to launch the first poll here, and let's see. And for those people in the room, I don't know if I can change the screen. There we go. So folks online, you guys are able to do this per question. Those in the room obviously can't answer this way. Giving him a copy. Yeah. Go give him a copy. Okay, so the first question is true or false? If we are a realtor and receive an offer for our listing on the non-member MLS access contract, we must present it to our sellers. True or false? Folks online, do you know how to get into your polls and answer those questions? You should be able to see those. There are. Did it just pop up? Okay, so you should be, oh, there you go. People are answering that question. Okay. Question number, so people in here, I can't hide their answer. I guess I could put their answers away, I guess. True or false, if I'm a realtor and I receive an offer on a non-member MLS contract, the best practice is to use the AAR purchase contract to counter. True or false? Okay. Let me go back to question one. Question one was, yes, you must present it. Question two, anybody here want to weigh in?
Who wrote the MLS
An attorney.
for the MLS?
The non-member MLS access, yeah, an attorney for Phoenix Association of Realtors, actually.
It's true because you can use you put contract, you counter with the contract.
That is what the question says.
Yeah. The counter from AR, I think.
Okay, so I think you're misreading that. The question is the best practice to counter with the purchase contract? Because you prefer the AAR purchase contract. So you're gonna counter entirely and get rid of the first version. So all of those of you that put true, those 4 of you, please know that please don't do that. You're going to counter with a counter offer. Okay, true or false? Number 3, both AAR and non-member MLS access forms are considered standard for the purposes of legal use and E&O coverage, errors and omissions coverage. True or false? We got answers there. We've got, let's see, 2 people said true. Whoops. 2 people said false. How about here? What are your comments? Says it's a standard. Is it a standard? Is it considered a standard? Errors and omissions insurance. Does errors and omissions insurance perceive that other contract you have in front of you as a standard contract? No? The answer is it is absolutely true. It is considered a standard of practice. There is not a problem with your using it. You are still covered on your E&O coverage. Okay. That's very important to know, because if you were not, I don't know that I'd want to be using it. Right now, if you get a,
Are there other brokers where it's not, you think?
Should not be.
Oh, yeah.
The insurance companies are considering that as we're teaching it. We're talking about it. It's not changing day to day. It's there. So no, standard means it's something that is used more regularly, because you could have somebody write something and handwrite a contract that fits contract requirements, but is that considered a standard? The answer to that would be no, because it's a one-off thing that.
The way the E&O company worded it, that it has to be a standard form approved by the realtor.
No, that is not what is.
That's the way ours, but.
Yeah, that's not Arizona's.
That's why I asked who.
MLS
isn't the association entity, right? The Joyce MLS.
It's called non-member MLS access.
Not affiliated with the association.
Correct. It's a non-member. It's away from the associations, and it was written by an Arizona attorney though. So, okay. Question number 4 on the AAR purchase contract. When is the earnest money due from the buyer? Within 1 business day, within 1 calendar day, within 72 hours, or none of the above? Wow, I have so many different answers here. Jacqueline is absolutely correct. None of the above is actually what is in the AAR contract. We will go through and show you more of that. And let me just get, I don't know what I can do with that. Let me just get rid of that. Okay. All right. So let's talk about, and bear with me, folks. This is going to be an adventure. This is not how I would normally do this, but the idea is to get you comfortable with both documents. So if you are a brand new agent, I think this is going to be a bit overwhelming. So take a deep breath. You do not need to take photos. I've given you copies of these things, okay? We are going to do the AAR purchase contract will most likely be the first thing that you see, and then I will show, and I'm going to follow as much as I can from that contract to what is similar in the other contract. And so here we see the beginning of the purchase contract. Now you'll notice, that's supposed to be coming up later, but that's okay. You'll notice buyer name on line 1, and then you can see 454, 455, and 456. Can anybody tell me where that is on the purchase contract? The AAR purchase contract, where, page 9, right? Okay, but here we go. On the non-member contract, you will see that at the very beginning, you have the buyer and all of their contact information. It's the very first lines 1 through 5. Okay. So let's take a look at, a couple of little key points. How many of you knew that there was a little pull down there that actually has an ampersand? So if you do have a buyer and seller, you can actually click the little caret and add the ampersand because it actually says and. Most of us don't really care about it. We know there are 2 entities there. It's fine, but just thought you might like to learn that if you didn't know that.
So if it's a drop down, is there an option other than and?
It's blank. If you don't do it, it just comes up blank.
But there's no other than and.
Mm-mm.
So there's no or. That's not a great way to.
No. We would not have that in a contract either. Well, or assignee,
Yeah.
but no, you probably wouldn't put that in there. So, I mean, you would write or assignee. Okay. So let's see, there's something else here. I don't know if you noticed this. Whoops, where'd I go here? Uh-oh, hold on. Let me go back. All right, there should be another thing that pops in there. I guess not. We'll come up later then. Seller. And you can see that the seller information on ours just is line 2, right? The seller's name. And then we go all the way to the back for the 470, 71, and 472. Theirs is all at the front, right? 6 through 10, it says the seller's name, mailing address, contact information. Email and phone number. Now, Title loves this because they actually would like to have the email and phone number. I don't know about you, but I really do not want buyer and seller getting the email and phone number for the other party. How many of you have had the buyer and seller talk to each other prior to closing? How many of you has that had a fun outcome? Yay. Yeah, I don't recommend that, but that is there. So, that's kind of interesting. That is not something I would recommend. Okay. So following that, at the very front, you will see 11 through 17. Guess what is all the realtor information? Listing agent, buyer agent, contact information, right? It's all right at the very front of the contract. Where is it on our contract? All the way in the back, right? Okay. So one of the cool things about this, though, is what is disclosed on the very front page of the non-member access. Did anybody see what I just highlighted there? Dual.
In a obvious way.
It's not, because where is it on our contract? Oh, look, way at the end in this teeny tiny little line that says both buyer and seller, right? But here it's up front. And think about that. When you're presenting an offer and there's limited or dual representation, shouldn't that be known before somebody reads the offer? Before you have that conversation? You don't need to take screenshots. I'll email all of this to you. Oh. Oh, okay. Oh, all right. You want to come down here? We've got seats down here. So yeah, it's so dual agent being right up front. Now, how can you as an agent address this yourself if you're using the AAR contract?
By presenting the limited representation form first.
By presenting the limited representation form first, right? So if you send, and instead of putting on the very top, your purchase contract, put the limited representation and agency right on top. Because that way they see that you're also with Realty One Group, right? Obviously, it's not yourself you're sending it to, right? It's sending it to another Realty One Group agent. And by the way, if you are working with a non-member who is with Realty One Group Arizona, is it a limited representation or not? The answer is yes. So, and one of our agents is like, what? So it is very true. So the Arizona Department of Real Estate, because we interact and because I, as a managing broker, can be managing both the, I call them TRIO, NAR, AAR, and local association members, realtors, right? And a non-member, because they can be out of every office, even though we do have 2 designated brokers, we are considered a limited representation.
Because the public can't tell the difference between HomeSmart Arizona and HomeSmart and Realty One of Arizona and Realty One.
Correct.
So they're still being, they don't want to be deceived.
Well, and also we can be in a room and talk to each other. We wouldn't be allowed to be in the same room and have that conversation, right? Does that make sense? Okay, so let's move on. So premises address, not a big deal, right? And so what is it that we actually sell properties by? The mailing address or the assessor number? Assessor number, right? The assessor number and the legal description are your keys to sell property. The title company really has a problem if you do not put an assessor number in there, because they need that assessor number to know that you're actually, your buyer and seller are actually agreeing to sell the correct property, right? Yeah. Property information, you can see the difference here because of the grid. Sometimes it's harder when it's just a single line to show that. I tried to indent the non-member version so that you kind of see it indented a little bit. But here it says property information, very similar legal description. They have property tax ID, folks. That's the assessor number if you did not figure that out, right? So it is there. Interesting point on this document. This document is for both vacant land and residential. Okay, so there's only one. If you are selling vacant land and you get this as your purchase contract offer, that is correct. Okay. All right. Okay, so I just threw some numbers in here. There are lots of ways to do this, and I did not actually, I really wanted to add, does anybody see any math calculations on this document? This is one of my pet peeves, and I'm sure there are other people that are going to argue with me, but nowhere near 10, 11, and 12 does it say 11 is subtracted from 10. There's no minus there. There's no calculation there. You can either subtract it in there or you don't have to. Totally up to you. Because what does a buyer have to do at closing anyway? What do they have beyond what these numbers show? Closing costs, right? These numbers do not show everything a buyer's bringing in, right? So my rule of thumb used to be if I had a first-time home buyer that was struggling with money, I did not subtract it out. Let it be a surprise at the end that they actually have that on reserve. It's already at the title company, right? With somebody that's money savvy, fine, subtract it out. They don't care. They've got the money anyway. They're not $4,000, $10,000 is not going to make a difference to them. First time home buyers, that $4,000 or $7,000 or $10,000 could make a huge difference for them, because they're like, oh my God, I have to come up with, $15,000 now, because they didn't calculate they also needed their closing costs, right? They didn't think about it until you're a week prior to closing and title goes, okay, you need to bring in another $10,000. And they're like, oh, I have to do what? Right? So it's your choice on that. I usually put next to earnest money to be used for buyer acquisition costs. Why would I use the word acquisition? What does that include? So if you put just closing costs, how does that money go to your down payment, for instance, right? So I'm sure that title has to give it back somehow or another because they can't, give it to the seller just randomly. But really, if you use acquisition, it can also be used for your down payment, right? Because the down payment is part of the overall acquisition costs. I would never put closing costs up there, but I have seen it on contracts. You don't have to put it that's used for anything. You can just be earnest money. You can leave that blank if you want to. I have down payment there. Obviously, if that's additional money coming in. On line 13, I had put first loan the other day and people looked at me very puzzled. Like, is that a bank? Like, no, it's back in the day when we used to do firsts and seconds because the line below that would be the amount of the second loan because we did 85, 15, and 5 down. So we would, put down first and then second loan. But somebody literally thought it was actually a bank. And I'm like, no, that's not the bank. I would not put the bank up there. I would leave it more generic. You can put conventional loan, hard money loan, or cash, right? If there's no down payment, you're just doing cash, just put cash. All right. So what is the one thing that Realty One Group does not have? We do not have a broker trust account. I should never, ever see that line checked. Lease or not lease, money can never go to the broker's trust account because we don't have one. Okay. It always goes to the escrow company. Please don't ever check that box. All right. Very similar, you will see purchase price, earnest money, down payment due at close of escrow, balance due at close of escrow. Now, they do have the word balance in there, so I don't know if that means that they're subtracting things out. That is more of a mathematical phrase that it says balance due, but it is, basically what's left in terms of whether that's cash or a loan, etc. So you will notice there's a little twist here. We were talking about when on the AAR contract is the earnest money due. And it actually says on line 18, right? Upon acceptance of this offer, the earnest money, if any, will be deposited with the escrow company, right? But on this other contract, it says earnest money shall be deposited into escrow account within 2 business days. Very clear. You know when it's supposed to be there. All right. So there are some really good things in this and good practices for you to observe when you are writing your contracts. You could add earnest money to be deposited within 2 business days in your additional terms. Actually, you could also write it just on line 15 above, the blank line. I don't think anybody would complain about that. All right. So close of escrow. It always fascinates me that people put close of escrow on or before, which first of all, you cannot put up there on line 24 because it requires a date. Says buyer shall deliver escrow company cashier's check funds to close, right? You have to deliver within a sufficient amount of time to close escrow. So if you're trying to close on the day and you're delivering funds via a wire and you send the wire that afternoon, that may not be time to close on that day. Probably needs to go out the day before or first thing that morning, okay? So other one is going to be very similar. Close of escrow occurs when the deed is recorded at the county recorder's office, right? And then over to the side here on line 49, close of escrow date. It must be a specific date. Look, they're being very clear. It's funny because line 24, you have to click on a little calendar, like to pick a date. But our agents love hurting themselves and putting in the back, on or before this date. It's okay. Does anybody know why we do not use on or before? And I will call it out if you put on or before on anything. I will tell you it's being rejected. Why? Go ahead, Jack.
Because the other party could demand closing before the actual date, and if the non-demanding party doesn't close due to their new demand, it would be breached.
Correct. You could be in breach if one of the parties demands that you close early, because you say honor before, you've agreed to honor before. And if you then don't close, you could potentially be in breach. It makes it confusing, right? It's obscure. They don't know what the date is. And think about how many dates in the purchase contract are specified based on what the close of escrow date is, right? When can you file the cure notice? When do you have to have closing docs? When do you have to have you're clear to close? I mean, all sorts of things are based off of that date. If you don't know that date, how do you know those other dates? There are a lot of them throughout the contract, right? The repairs need to be done within how many days? 3 days prior. Okay, you don't know when closing is. How do you have your contractors lined up to do that? So please use a specific date. Similar things, possession, deliver of possession, date to record. If the recorder's office is closed on the close of escrow date, it obviously moves to the next business day. And there's must be a specific date. So we've got that detail. Buyer acknowledges that failure to pay the required closing funds by the scheduled close of escrow, if not cured, after the cure notice is delivered, could be a material breach. Buyer must have the funds to close, right? And all funds are US currency. Here we have on the other side, failure to pay, buyer acknowledges failure to pay could be a material breach, right? Very similar language, just different locations. Look at the number on the side of that. What are those numbers? Can you see that? Line numbers 351 and 352. This is way at the back. The AAR contract has it way up front. So there are certain things that go back and forth depending on what order they put them in, okay? They also have funds necessary to close. Buyer currently has those funds. This is earlier. You can see this is in the 100 series. They have to have those and is not relying upon a contingent source of funds. Isn't this interesting? From loans, gifts, 401k disbursements, etc., except as follows. So they require that the buyer tell that to you. How many times have we had a buyer, oh, we're waiting for that funding to come in. They're waiting to sell that stock, but I don't want to sell it yet. We're gonna wait another few days. Okay, we'll get it. It's coming. They have to disclose this up front. Your seller gets to know that, right? So delivery of funds, of course, agrees to deliver down payment deposits in sufficient time to close escrow. Same thing that we had on the page before. Possession, so this is jumped back to the AAR contract. You can see with the little 1E and then lines 32 through 35. Possession occupancy is based on, and that you're supposed to get keys to locks, mailbox, security systems, alarms, and common area facilities. Our AAR contract does not actually have the smart home stuff, which is kind of interesting. This is talking, I jumped to pull their pre and post possession. This is informing people to get, information regarding that. And this is, of course, talking about that. Let's see whether they actually have, this says garage door opener. It does say security system and alarm codes. So neither one really talks about all of the smart stuff, but I think it's later on in this that it does talk about it at one point. So. Okay, we're still on page 1, right? AAR contract still on page 1. I flipped through, I don't know, 10 of the pages of the other one. So we have a lot of things that are addenda incorporated. What you will find on this other purchase contract is that a lot of those other things are actually built into that other contract, okay? I'm not going to get to all of those today. Those will be next Tuesday because I'm trying to go through our contract first. So anything that is outside of our actual purchase contract, I'm not pulling it in until next week. And I will show you how all of those lay out. But for instance, if you see Addenda Incorporated, you only see 3 items on there. So we'll go over those in a few minutes. Let's see. Then we jump in our contract to fixtures and personal property, right? I didn't have a way of trying to make this smaller. So you can tell from 39 to 67, actual fixtures of personal property, and then leased items, things that are, personal property, otherwise, not otherwise addressed. You got a couple of blank lines. Refrigerator, washer, and dryer, it asks for a description. What is really the preference for that? What should you try to put down there? Model number, serial number, model number is ideal. The manufacturer, a description like on a refrigerator that it's a stainless steel French doors, right? The 2 that open up, or a side-by-side with water and ice on the front. Does anybody know why this is in our purchase contract? Because they got switched out. Back in the day, I can't tell you how many times the buyer showed up and that avocado green side-by-side refrigerator was all of a sudden there instead of a black, fridge and freezer, right? And you're like, wait, where did that come from? Well, it just said refrigerator. That's all it said. So people try to say as seen on. Well, do you know what was seen on that date? Do you remember? I've been in 10 homes showing, I don't remember what was in on that date, right? And now you're 30 days further down the road, right? So please, if you're out showing with a buyer and they're showing interest in the property, take a photo of your listing, right? So you have the address, by the way, that's why. Take a photo of your listing, then go take a photo inside the fridge. Because if you don't take a photo of your address, you won't know which property that fridge belonged to, just as a hint. You go through 10 homes and you got 10 photos and you're like, I wonder which one was which.
Offers where like the washer and dryer, they'll say as seen in the MLS. I'm like, I don't know washer, I don't have a picture of their washer dryer in the MLS of it.
Right,
It's like asking in property and MLS. I'm like, no, you didn't.
right. It's not in the MLS, right? So, and how many times have you seen a refrigerator in the garage? Which fridge are you actually getting? So be specific, make sure you get that model number, all right? So here's the non-member version, very similar, a little bit smaller. And look, washer, model, dryer, model, fridge, model. Giving you guys a hint because description apparently did not work. We've had description in there for years. Like, we say description, but they really don't put it in there. So let's tell them what they should be putting in here. All right, so, oh, look, love this phrase, right? All personal property not included in the sale and debris. What a novel word in there. Debris will be removed from the property by close of escrow, right? Leased items do not convey. Seller shall disclose all leased items within 3 days of contract acceptance. Buyer shall have 5 days after receipt of such disclosure or within the inspection period, whichever is later, to cancel the contract for disapproval of leased items that do not convey. Water softeners there. You kept asking the seller, is it leased? No, I own it. I own it. Buyer writes their offer, thinks that it's owned and it's leased. Could have a problem. Who ends up buying a water softener then? Who knows how much a water softener costs these days? How much?
1,200.
1,200? Okay, how about
I just threw it out there.
$4,000? It's $4,000 to $5,000. It's not 1,200. So, all right.
What about solar?
Solar is on another, should have a solar addendum. Notice where their fixtures and personal property is. 158, we were on what, 60? Somebody tell me what numbers? 39, right? Our fixtures is way up front. It's way in the back here, right? So just keep an eye for where things are. All right, let's see if I can get another poll here. I'm going to switch to this so you guys can start thinking about it while I, we'll get both of those on there. Let me find my poll if it will come up. So folks online can participate. Back. Try poll 2. Okay, Jason, let me know when it comes up on your computer. On the AAR purchase contract, when does a buyer need to notify the seller of any changes to their lender or loan? So the answer to the question is immediately. All right. And we had a little conversation about that, but the challenge that we were discussing was if the changes impact the seller, but that wasn't what the question was. The question was, how soon do you need to notify? The notification needs to take place immediately. Do you need to get a prior written consent? That's a totally different question. But you do need to notify if there are changes in the loan program. So, all right, second question. On the AAR purchase contract, where does the buyer disclose if their down payment or other funds needed to close come from a gift, third party, or otherwise non-liquid account? On the PQF LSU, in the additional terms of the purchase contract, or this does not need to be disclosed? Any answers? Well, everybody online's all over the place. So on it, does anybody know that where on the AAR contract, where the down payment funds are coming from is disclosed? Prequel? The answer is it's not. It's not on the AAR contract. It is on the non-member contract, however.
I'm just going back to the changes in your loan, it is immediate that you have to put it in.
No, it is not.
You can read it.
Okay. It's not, unless you need to read later. It says,
It says, buyer shall immediately notify the seller of any changes in the loan program, blah, 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 pre-qualified. Within 10 days after contract and shall only make any changes without prior written consent of the seller if the changes do not adversely. affect-
correct. You don't need to because, correct. You don't need it unless, you don't need consent. You don't,
I'm
no,
not asking you about consent, but it still says you have to tell immediately.
no, it said, it says unless it adversely affects. So that's the question, was it, if it doesn't adversely affect, it does not adversely affect, you don't have to notify them at all. So the first part of that says if it does, then you immediately have to notify them. Yeah, Jason? So if you go from cash to financing, well, I don't know that I have the doc that where I can show this, but so the challenge with that is, they cannot, well, they can go to financing because that's fine, but they have no financing contingency. They have no appraisal contingency. So you can't all of a sudden re-add your financing section. If you notice, actually, this perfect place. If this is an all cash sale, section 2 does not apply. So if you want to say all of a sudden, I'm going to get a loan on this, that is fine. And you do not, again, have to notify the buyer or the seller of that as long as it does not adversely affect the transaction. If you're closing on time, there's no added cost to the seller. You can't add appraisal and there's no financing contingency. So as long as your loan goes through, you're fine. If your loan doesn't go through, you're closing in cash. Does that make sense? Well, yes, you'd lose the earnest money. Yes. But I'm not, yeah, I don't know that you'd lose the earnest money. I think the seller would sue you. Right? Because you didn't disclose and it did adversely affect them. Right? So as long as you know you're going to do either go with the cash with no change in it, close of escrow, or you're going to close in cash, you're fine. And we did have that a couple of years ago. We had an agent that the buyer just found out that it would be better for them, instead of using their cash to do the loan, they had the money, but they were gonna close in cash and then pull a loan out, right? Well, that's more expensive to do than to buy it with the loan. But again, there's no appraisal contingency, no financing contingency. You have nothing on there. You can't all of a sudden say, oops, can't close, give me my earnest money back. So, all right, so here's the financing section. Pre-qualification is attached, right? Is attached, and it's very specific. The AAR pre-qualification form is attached. All right. There says, here's the new loan information. So this is giving some of the information we had, will be next, I guess, the FHAVA convention, all that stuff. They actually have a box for hard money lender. A lot of people don't put that down. They say cash, and it's really a hard money lender, but that's fine because they're not using the financing section then. Because a hard money lender doesn't, I mean, they require an appraisal, but it's a totally different appraisal. Usually does not affect anything, but it's not contingent on that because they're not saying it's a loan. They say it's cash. Okay. This does actually say type of loan, hard money lender, which means you do have the financing section applying, right? So, let's see, if there's no new loan, right? No, you skip section L. So similar to ours, all cash sales skip section 2. There's a skipping section L, okay? Their contingency, they have this sale is contingent upon buyer obtaining the property for a loan. It's contingent on a loan, that's fine, there's a contingency section, but pre-qualification, lender's pre-qualification form or letter, let's see if I highlighted that. Oh, I did not. So this is not obviously the AAR form. They're allowing a lender's pre-qualification form or letter. So you get either one of those, whichever one you want. It's attached, or they've pushed it back out like our old contract used to be. You could get it within a certain number of days. Well, that's fine, but your seller has to know that then they don't have that information, right? They don't have it to review when they're reviewing the offers. So if you have multiple offers, how strong is that offer if you don't know what their financing is, right? You have no idea. So just some things to think about. I threw in our notes from the AAR contract. You can see type of financing. We do have the box that says a blank line where you can write hard money lender. I have seen people do that. If it's to be other than new financing, see attached addendum. That's on ours. We do have that information there. Loan costs. Costs for obtaining the loan are paid by the buyer. Same thing as theirs, line 114, loan costs, all costs associated with obtaining a loan shall be paid by buyer. So very similar language. So again, don't be afraid of this. Just look through and look to see what you need. Oh, look, I did highlight that. I thought I had. Okay. All right, delivery of funds. Buyer agrees to deliver the funds to escrow company to pay down payment. Then we get to unfulfilled loan contingency, interest rate, necessary funds. So let's see what theirs says. If it's contingent, right? Contract should be canceled up above. You're seeing a contingency there. Funds necessary to close. Some of the sections kind of came through and some did not. So the funds necessary to close on the non-member says that they are not relying on any contingent source of funds, right? From loans, gifts, 401k disbursements, except as follows. I think that's really important to know. And we don't have that in our AAR contract. That would be really useful to know where that money is coming from. So something to consider. Okay, let's see.
Probably be best practice to hold the buyer in case it didn't work out when you have something.
It would be best to say this is contingent on receiving funds from, so that you have a way to get your earnest money back if for some reason that, that doesn't happen. So obviously the AAR form has the loan status update. The non-member is not going to have that, but they do have loan updates requested in there. So even though they don't have the form, The buyer is authorizing the buyer's lender to provide non-confidential information to the listing and selling licensees regarding buyer's loan application status. So they are granting you the right, excuse me, to talk to the lender and get that information, right? So that's good. There's just no specific form nor a specific timeline, right? So if you get this contract as the listing agent, you need to pick up your phone and call occasionally to find out that information, because there's no set timeline they're going to deliver it to you. Okay. Buyer agrees to keep seller promptly informed of all other material non-confidential developments regarding buyer's financing and the timing of close of escrow. They say they're going to communicate. How many times do we know that they probably aren't going to communicate, right? So seller is going to have to do stuff with that. Do I have anybody in here that is using the non-member? Any of you using the non-member? Okay. So my purpose of this is to help you understand, if you receive one of these things, not to panic. And we're going through it to try and learn. Did you get a copy?
No.
Check down there, see if there's another copy. There you go. So, all right. So loan application, unless previously completed. So that's what's on the AAR contract, right? 3 days. In the non-member, it says buyer shall apply for a loan not later than 3 business days. So they just added a little twist there. It's not 3 days, it's 3 business days. So if you go under contract on a Friday, they don't have to finish their stuff till Wednesday, right? To put that application in. The other buyer on an AAR has to be doing that by Monday. Does that make sense? Okay. So little twist with language there. Loan processing during escrow within 10 days, receipt of the loan estimate, knowing that the buyer has the notice of intent to move forward. And I did not find that on the other one. So there was no place to see that the buyer has to actually say, I'm working with this lender. Hopefully they're moving forward with that lender, but there's no place that you actually get confirmation of that, right? Because again, that no LSU. So if you're the listing agent and you get a contract like this, make sure within that 8 to 12 days, you are reaching out and saying, where is this? Where are you on this file? Make sure they're still involved. A couple of weeks ago, we had an agent that, the buyer that we represented the seller, and the buyer had changed their lender. They didn't find out till later. So it's like kind of important information for all parties to know if you're changing who the lender is, right? So this is saying, this is ours, buyer shall notify seller of changes in the loan program, right? This is the section we were talking about. Shall notify immediately, financing terms, etc. With attached here to within the 10 days, the contract acceptance, this is for the LSU, and shall only make any such changes without prior written consent if such changes do not adversely affect buyer's ability to obtain loan approval without prior to doc conditions, increase seller's closing costs, or delay close of escrow. So I think to your point, this is saying that any changes in the loan program financing terms attached here to, or the LSU provided. Now, you can deliver the LSU with those changes on it, because the LSU then trumps your prequal, okay? And it becomes the new standard. All right. On the other side, loan changes, very similar, buyer changes. This is saying buyer shall notify seller and provide an updated form or letter within 2 days of changing the lender or the loan. It's a little different there. And lender makes a change to the loan which adversely affects, right? So if after issuing the form, lender makes a change which adversely affects, then buyer shall not agree to such loan changes without prior written consent from the seller, right? Any changes that are going to adversely affect need that in writing. So very similar to ours in terms of that. Okay, right to cancel. Seller shall notify buyer within 2 days of seller's approval of those changes, or B, seller's decision to cancel. Here is an opportunity for the seller to cancel if the buyer is impacting those changes, right? If it changes the close of escrow date, seller can say, nope, not doing it. Right? So, earnest monies refunded to buyer, yes.
So I'm a little bigger, as far as 2K goes, with the, with the,
AAR contract?
yeah, AR contract. Do you have to disclose or do you not have to? I guess I'm a little tied up on.
It's hard to predict what will adversely affect the process, I think, so I think it would be better safe than sorry.
When in doubt, disclose. That's a very good. Shall immediately notify seller.
And then it said, and you can
Prior
only
to
make those
written
changes
consent.
without the prior consent of written consent of the seller if it changes the thing. You really do have to notify that you changes immediately.
All right,
But
well,
but like if my client said, on the buyer, I'm changing the lenders. They're fine with their appraisal, we're still gonna close in time, it's not gonna cost the seller anything, I'd say, okay, do it, but this is close, that's fine. But if they called me and said, I'm going from cash to a loan now, I'd say, okay, hold your horses, let's get an addendum going, saying section 2 now applies. Here's our pre-qual, blah, 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 and then the seller signs that, then I say, okay, go ahead. So it's like you can't make a change without the seller's written consent, but you do have to notify the seller of any changes.
well, so if your buyer wants to switch from cash to a loan and wants to put into place those contingencies, yes.
Well, maybe that was a bad example.
Yeah.
but You know what I mean, it's gonna have to be like, get the written consent from the seller before making it.
Correct, because the seller has the right to say no, right? So,
You can't, they know unless it affects the.
correct. So, and again, you can issue the loan status update if you're using the AAR contract that could have that information on there. And once that's been delivered, they've received that notification.
Yeah, within the first 10 days, they can switch under all they want.
Mhm.
They did that, like, do it one time thing.
Right, yeah, so, okay. But, go ahead,
Move on.
the prequel, go ahead. I don't have a copy.
Well, the lender information, so if they're gonna change that after, like with the if the LSU is different than the pre-qual. And it adversely affects the loan, you should have dealt with that, maybe.
But the LSU could be used to notify that you've switched lenders, which you have the right to do in the first 10 days. As long as it's not changing the close of escrow or costing the seller additional money. Right? So if you've got a scenario where the seller's paying the closing fees and maybe it's changing that would be a difference, right? So, okay, appraisal contingency. So 107 to 114 appraisal contingency. It's contingent upon the appraisal of property, appraisal costs initiated by buyer, seller, other. Let's see what's on the other contract. Here it says almost the same thing. If appraisal is required prior to close, charges are agreed as follows. Buyer pays, seller pays. Paid by seller, reimbursed by buyer at close of escrow. Appraisal fees are non-refundable and payable immediately. If seller's paying the initial fee, they've added this, which is fascinating. It is included in any concession indicated on line 29. So their line 29 is those concessions that if the seller's providing concessions, right? So in this scenario, they're saying it's not even negotiable. If the seller's paying that up front, it's already a part of what they've agreed to. It's not in addition to. Does that make sense? So that's one for title to know that, right? Because it's often confusing. Okay, the seller's providing $2,000 in closing costs. Oh, but they also have to pay the appraisal up front, but it's not a part of what they're already paying. So this is very clear. If they're agreeing to pay $2,000 and they pay the appraisal up front, that is subtracted from the $2,000. So it's clearer for you to understand that. I like that. Nice. Again, some clarity sometimes. Okay. So, and ours says that up top that the buyer's lender requires an updated appraisal, then it is to be paid by the buyer. If there's any updates, The AAR contract says that. And then it also says it on the bottom here, the buyer shall pay reinspection fee required by lender. So both of them delineate, if there's a secondary appraisal inspection required, buyer pays it, period. Okay? Only time I've not seen that is if it is a flip that the seller is doing in short order, or it's a quick flip and they have to get two appraisals. And that's actually a second appraisal. Usually the seller will pay for one of those appraisals outright because they're doing the quick turnaround. But not a matter for this. So appraisal contingency, was up above. Again, they have it as well. I just put them in different sections there. They have lines about right to cancel. If the buyer does not cancel the contract within the 5 days after notice of appraised value, then the appraisal contingency shall be waived. Very similar. So this is interesting. So for any cancellation based upon this appraisal contingency, buyer shall deliver a copy of the written appraisal to seller upon request by seller. That's actually not in our AAR contract. It's not required. Now, I've always done it, but it's not actually required. Which seems weird. You're telling them you're canceling based on the appraisal, but we're not going to tell you what the appraisal was or why, right? Because it's not just that dollar price. The seller wants to know what comps were pulled, like what was used, what am I comparing to, or what's the square footage? Yeah, that's a good point, right? So waiver, there is on their contract, on the non-member, there is buyer waives the appraisal contingency. So that was a thing for a while. We had a lot of those that we did have the buyers waiving the appraisal contingency. So it's just built in. Okay. Seller concessions, that is on the AAR contract. And, oh, wait a minute. There's more than just seller concessions here. Look at this. Okay, so seller concessions. Seller will credit buyer a percentage or a dollar amount. Now look what is right next to that, folks. How handy is that? Seller will pay buyer's agent compensation in the amount of. So is there confusion between lines 36 and 37 and 38 and 39? That was good. Probably. No. So you've got both of them right there so you can see what the breakdown is between the two. You know what the seller concessions are and you know what the seller compensation to the buyer's agent is. Cleanly laid out, okay? Now, I want you guys all to read, I'll read it out loud, but 40 to 42 is consent. And I really want you to understand why, and I'll explain this in a second, why this is so important. They've added the language, if applicable, buyer and seller consent to buyer or broker receiving compensation from more than one party to the transaction. Buyer and seller explicitly intend brokers to be third-party beneficiaries of this contract. The provisions of this clause shall survive close of escrow. So, let's look at the seller compensation addendum, because I've been getting a lot of people that want to counter and basically not use the seller compensation addendum. Now, remember those 3 lines I read up there, and think about if you throw away the seller compensation and just write in a counteroffer, seller agrees to pay the buyer. Okay. That removes the ability, 1, to receive money from more than one party, and 2, that your third-party beneficiary is the contract, and 3, that the provisions survive close of escrow. Please use the seller compensation addendum, right? Because if there is an argument over your commission and you agree to close, you have the ability to pursue after close of escrow. If you do not include that, you're done. Okay? Do you understand why the seller compensation addendum is not one line? There's other stuff in this addendum. So if all you take away today is how to use your seller compensation addendum, score. So, yes,
So I'm seeing a lot of SCAs coming in with a percentage and then a counter offer changing it. Is that the proper way to do it?
is the seller comp, well, let me go to my next thing. So let me put the next part of the seller compensation addendum up here. So this is what you're talking about, right? So let me ask you this. Is the seller compensation addendum executed or not?
This one's not.
Well, the ones you're talking about that have been countered, yes? How many of you have countered a seller compensation addendum and not had your seller sign that SCA? Didn't get it back?
Another addendum we have now.
It's another addendum. So what I've been calling agents with and asking them, so if you countered an HOA addendum, did your parties execute that HOA addendum?
That brings it into the contract.
Oh my gosh.
Yeah.
Jacqueline just said they had to have because it brings it into the contract. It's an addendum, folks. If it's not executed, it's not a part of the contract. So to answer Title's question earlier, so let's say line 10 says 3 potatoes, I don't care, whatever, says a number there. It doesn't matter what the number is, right? And there's a counter offer issued and it says, the counteroffer says seller compensation addendum line 10 shall be amended to read 2 potatoes, right? Totally fine, right? Because you have not deleted your seller compensation addendum. And look up above, right? That this says that undersigned consent to receive compensation for more than one party of the transaction, that they explicitly intend brokers to be direct third-party beneficiaries of the contract. Provisions of this addendum survive close of escrow. When you guys are not using this addendum, you are not protecting yourself as a buyer broker. Does that make sense? It's so important. And yes, you must sign, both parties must sign this addendum. Better yet, not better yet. I just had somebody that the seller wrote a new seller compensation addendum.
If it's checkmarked on line 37, then it's then the appropriated, then even if they forgot to sign it, and they get a counter and they sign it, like, the intent is all still there, right? And you can still get it signed.
You can still get it signed, hopefully.
HOA.
Correct. You've got to go and get it signed. But I've had people that instead of using the counter offer, the sellers just created a whole new seller compensation addendum. So could somebody tell me what happened to the first addendum?
We'll pretend it didn't happen.
The original SCA, which of course ends up in my files. Like, wait, why do I have 2 SCAs? One's well, who knows if they're both executed or not, but it's like, you guys, you can't write addendum 1 and then send it out and then, write another one. So be very careful about that, right? Make sure you're remaining consistent. It's an addendum and a part of the contract. So, let's see, title and escrow, trying to see what time we're on. Okay, we're pretty good here. So, okay, I'm still going. I'm doing good. I got a whole other section here, but 2 big sections, title and escrow, very, very similar. If you will notice, like, oh my gosh. Okay. Thought I had that off. It's not gonna let me to do that. So title and escrow, their title and escrow, of course, is up front. They really show in the first page, they try to go over as many of the participants to the contract in the non-member version. Ours is somewhere, a couple of pages in there. And then title investing, let's see, I think they have the same thing, that advised to seek legal, they have advised to seek legal counsel here. Where is this? in how to take title. So similar thing, right? They are to seek legal counsel. Are you to tell the buyer how to take title? No? Yes? No? Is the title company? No. Do you know how financially you could change somebody's scenario depending on how they take title? Please do not do that. Tell them to seek legal counsel. Tell them to Google it if they want to Google it. That's up to them, but don't you give the Google version, okay?
Oh, yeah, don't send the link to a search, rather than do their own search.
Yeah, just say search that if that's what you want to do. I would say seek legal counsel. You just have no idea, you know, are they, have they been married before? Are there multiple sets of kids that are involved in this? If they take title as, you know, a community property with right of survivorship and there are kids from a previous marriage, there can be all sorts of issues with that because those kids may have rights, and if they have
There's
Uh,
no pamphlet from really one group with the nothing, okay.
no, and there's no pamphlet. You have a little
We have
sheet of
form
paper,
that Says the different ways.
but you need to know that that form does not tell you the tax consequences. And there can be huge tax consequences if you've ever looked into it that can impact them, and you don't know their situation. You may not know all the players. So really, really important. All right. Title commitment, title insurance, lovely little section. So maybe Roberta, you can tell, is there a difference between the Alta policy that is stated on this bottom one? I don't think yeah, it says on line 129, American Land Title Association, okay. If applicable, buyers shall pay the cost of obtaining it. I think it says it up above as well, buyer's own additional expense. Does the AAR actually say that escrow fees and recording fees are to be split equally? Do you know? So they spelled that out. It's what title does anyway, but it's just nice to have it spelled out there. So receipt of title commitment, the buyer shall have 5 days. So very similar. Most things are, if they're given notice, the buyer has 5 days to respond to those things. Okay. Additional instructions, these are a lot of other things. I'm not going to go into all these details, but information, affidavit of disclosure, out of the way here. If it is in, if it's not in a city, is that right? If it's not in a city boundary, unincorporated area, you would get an affidavit of disclosure. So just additional instructions there.
An AA form, not.
The affidavit of disclosure is an AAR form. Yes, I'm sorry about that.
Something we provide.
Okay. Release of earnest money. So here is going to be a little twist. So in the release of earnest money, it says that in the event of a dispute, it is up to title to handle it. In this other one, it very clearly says the escrow company will not release earnest money without first receiving either an earnest money distribution agreement signed by all parties or a judgment from a court. They've taken it immediately away from title and had taken it into either mediation, I guess, arbitration, or being handled outside title. Title's thrilled with this. They'd love to see that in ours.
I like the part about the both signing.
Well,
Mutual consent.
mutual, yeah. But trying to get sometimes those details is a challenge. Okay, tax prorations, prorated as of close of escrow. This is the AAR contract, prorations of assessment and fees, assessment liens. Let's see. So on the non-member, you go to prorated items, date of proration, whether it's close of escrow or other, which was available above, and items and things to be prorated, assessments. So that's all pretty similar. Okay. Seller property disclosure statement. I do not have the other one, but they do have a seller property disclosure statement. Basically, seller acknowledges and agrees that they're going to be delivered, and they even did call it SPUD. So that So within 3 days, they kept that. Buyer has within the inspection period or 5 days after receipt of the spuds, whichever's later, that's fine. So insurance claim history, this is what ours says, and I want to point out that the AAR contract says seller shall deliver a 5-year history, claims history regarding the premises, or for the time the seller's on the property, right, if less than 5 years, from the insurance company or an insurance support organization or consumer reporting agency, or if unavailable from these sources, from the seller within 5 days, right? Buyer then has the 5 days to respond. This says that, and this is the one that I actually am not happy with, within 5 days after contract's acceptance, seller shall provide a 5-year insurance loss history report, and they are then classifying that as a CLUE report. Does anybody here other than Melissa know what CLUE actually stands for? Comprehensive Loss Underwriting Exchange. Thank you, Jess. I knew you knew it.
Yeah, I'm thinking in my head because it's so hard to get.
It's good, it's an actual thing, it's not insurance.
So it's an actual thing from Nexus, Lexus, or whatever it's called. And it's $75, and you have to actually be the seller. The buyer can't go get it. It's really hard if you're not if you aren't an owner of the property, right? So that is a challenge. And this does not give you any other option, right? So this would be the one thing that I would counter in receiving this contract is I would absolutely counter that out and say that they will either provide an insurance history report or that the seller will provide their knowledge, right? Yes.
So mechanically, if you're not getting a CLUE report, where are you getting the insurance claims history?
So the CLUE report is only orderable through this LexisNexis. You cannot get it from your insurance company. The other, you would call your insurance broker and say, can you please send me a 5-year claims history?
And they can get that without buying a CLUE report.
They just send you a letter. They look in their computer system and go, no claims.
Some insurance providers will get you a clue, but it's very.
Yeah, it's few and far between because of the cost. It costs them as well. They don't want to do that unless they're writing a policy, and they do pull them, but no. So that is one thing I definitely would not stay with. Okay, let's see how we can go here. Foreign sellers, they both have foreign sellers, right? This is a big thing here. This may be an interesting area if any of you are working with Canadians. So we'll see whether we have an increase in Canadian sellers over the next 2 months. I believe I was told that somebody, and I did not read this myself, but somebody said that Canadians are going to be required to register if they're here for more than 45 days.
30 days.
30 days.
Already, no.
Right. So the question is whether any of our Canadian people that are, folks that are here for their 6 months are going to say, no, I'm not doing that, and decide they want to sell in the next 60 days. It'll be interesting. We'll see. But affidavit of disclosure, if the premises are located unincorporated area, I had that earlier. Escrow company shall deliver to all parties. Let's see. So I think a lot of people don't realize this, and this comes into effect with the BINSR. One of the reasons you do not send the BINSR to title unless it's for cancellation is because an escrow company is required to send to all parties access to materials information regarding the escrow, right? So they get something, they've got to send it on. I know this is talking about the affidavit of disclosure, but it's important that they are sending everything on to the lender, to the other party. So it's like you're sending over the BINSR and it says, we're going to do this stuff in lieu of, technically that's supposed to be sent to the lender. Like, but I didn't want it to go to the lender. Well, don't send it to title. BINSR does not go to title. All right. I do have the lead-based paint. I threw that in there. Is this going the wrong place? Oh, how did I do that? Oh, no, I'm right. Okay, so I have the pages over here. Okay, so lead-based paint. Theirs does not have initials here on the contract. It's kind of interesting. It just says you need to do the lead-based paint, which is fine. And then, right to cancel, they have the 5-day right to cancel within the lead-based paint. That's fine. I have thrown this on here. Can somebody tell me what entity manages or oversees the lead-based paint disclosure?
Department of-
Environmental Protection Agency, the EPA, right? So does everybody understand that if this part of the document has not been filled out and you represent the buyer and you give them this bottom section, the first line says, buyer has read the information set forth above and has received copies of the reports, records, other materials listed above, if any. And there's nothing above. Do you understand that if you have your buyer sign and initial this, every place they initial, you are liable for the mistake. Every single one of them. If the EPA were to audit our files, you as the agent are liable for the fine. It is very hefty. I'll just make sure you know, the maximum penalty is $21,000 for each violation. Now, that's usually against builders, but it's usually $1,000 per error on real estate contracts. So let's go back up. 2, 4, 6 initials, 2, 4 buyer signatures, your initials and signature. That's 6, 7, 8, 9, 10. That's $10,000. And you guys wonder why I call you and say, I really not wanting to sign this and go ahead and let this go through. And I get, seriously, folks, I get this at least once a month. That somebody has sent it in that they have signed this prior to the seller signing, right? Or there's some other error in it that they didn't, follow the directions. So again, just want to share that to you. I pick up the phone and try to say, if you're comfortable with a $10,000 fine, I'll put it in the file. That's on you. You're telling me you want to close this file and you want to be paid. I'll throw it in your file, but it's on you. You're going to get that fine, not us. Okay.
Fine, might be
No,
fair.
you know, question.
Oh yeah. $10,000 might be greater than some of your commissions. Okay. Well, I don't know what this is. Why? Oh, that's not what I wanted to do. Sorry, folks.
Just blow your face.
Yeah, blow my face up. That is not what I wanted to do. I'm trying to get it out of the way. Oh, I don't even know how to do that.
Show online.
Thank you. Glad to know that.
Like, I'm still here, everyone.
Thank you. I'm glad to know that. Yeah, I don't need any bigger there. Okay, changes. So again, they kind of mimic the changes here. I'm trying to get through here because we're going to end up, okay, warranties. I don't think I'm getting through disclosures. Condition of the property. I love this, right? So how many of you know that our current contract, people don't seem to understand, buyer and seller agree the premises are being sold in its present physical condition as of the date of contract acceptance. That equals as is, just in case you didn't know that translation, right? So they decided that they would just simply write as is condition and home warranty, right? So buyer acknowledges that it is in its as is condition without expressed or implied warranties, right? If your client is asking you to write that it's as is, it already says that.
We have to ask what-
Are you not asking that you're gonna request repairs? Although I just had somebody that did that and then got bit because they then found they needed to ask for repairs. So it was like, okay. But so then they had to negotiate everything on the side to be able to get an addendum. Hopefully they got the addendum, but it was like, well, so what exactly is the intent? Right? So please look at that. This goes on to the home warranty, but let's keep going here. Warranties that survive closing. This is very similar, right? There are known material facts and defects, those survive closing, folks. If they've got carpeting down and they just put the carpeting down and there was a huge crack across the whole room. Oops, forgot to tell anybody that there was a crack there. Right? That would be a problem, right? So again, similar things, no material facts, seller warranties. Warranties that survive closing. So I've got both of those. For some reason, they have 3 paragraphs to R1. I'm not quite sure why. Didn't go through line by line to see whether that's something else. Then we've got buyer warranties, right? Buyer warrants the buyer's not relying on any verbal representation concerning the premises except as disclosed as possible. Oh my gosh, thought I got that turned down. Then they've got buyer warrants, they're disclosing anything, and then they say unless disclosed herein, but there's no place to put it. So you would have to add it later on, that's fine. If you are using the AAR contract, please write the word none in there. It takes 2 seconds. You can even put it in your template, right? So the only time I wouldn't put the word none in there is if you have a client that has never seen the property and you did not go do a video tour of the property live with them, right? Somehow so they physically could walk through the property, because that's the challenge, right? We go to a property and actually physically see it. There's a big difference than the photos. Even through the little virtual tours, which you get to lick up and down and wander around, right? But there's still a difference, right? Smell is one of the biggest, right? What does the home smell like? Are the ceilings really low, right? If you've got a tall buyer and you've got 7-foot ceilings.
Do you recommend putting anything on those lines when you do a virtual?
If I actually go do a virtual tour, I'm fine with saying they're not relying on verbal because you walked them through the property, right?
And it's talking about verbal representations from the seller or just from us or anyone?
Anyone, right? They got a call from their cousin going, oh my God, you got to buy this house. It's a great home. Awesome. So close to where, you know, they're building out this thing and that, or going near the Glendale Stadium. It would be great for a Airbnb without looking the fact that there are, you know, 7,000 Airbnbs like right there as well. So that's the idea. If they're taking verbal representations from somebody else and not doing their own due diligence, that's when you would write something in there.
I think that's like the most underused part, because like if you go show a buyer, for some reason the seller's agent says like, oh, that cracked window, the glass is on order or whatever, that should be in there when you make your offer, like they are relying on the seller to replace the cracked window, whatever, you know, because people are such that thing about everything.
So, right. And I probably wouldn't use that. I would probably put that in additional terms and conditions that seller agrees to replace the window or whatever prior. All right. So, I think we are going to, let's see, we can do the poll. If I can get it back up here. Oh, let me see. Get to that. Let me go back. We will launch this 3rd poll, and then folks, it is almost 11:30. I did not get through disclosures. I was trying so hard, but it is a huge section, so I will hold off on that. According to the AAR purchase contract, in the case of an earnest money dispute, who determines the disbursement of earnest funds? Buyer, seller, escrow officer, title company, or the agent who fights the hardest? Love that. Love that. Go for it. Escrow and title. Number 2, if HOA information is missing or incorrect on page 1 of the AAR HOA addendum, who is responsible for those missing or incorrect fees? Buyer, seller, it's split 50-50, or is marked on line 75 of the HOA addendum. How many of you are filling in line 75? Oh, it says line 74. That's funny. No, it's line 75. How many of you are filling that in? Please, please, please. If you want 50-50 split, that's fine. Put it down, but put something there, because if you don't, title is like, I don't know who's paying this, right? And what time of year is it most critical that you fill this out? in the beginning of the year, because when do HOAs make their changes? January. So if they filled out the form, if your seller filled out the form in September or October, they may not have known of the changes for January. All of a sudden, you're in January or February. Nobody went back and changed that HOA form. Now you've got different numbers there. Who's responsible? The seller should be, right? But in that case, if you didn't fill it out, might be the buyers dealing with it. So let's do that. All right, let's see what I have next here. I think I have another poll. We are going to stop right here, folks. Thank you. Our friends at Av Luxury Living brought us lunch today. So please stick around. There are sandwiches in there. Help yourself. We can continue and have a fun little discussion. I don't mind. Folks online, thank you so much for being here. Don't forget to send me an email and I will send you the information of all of this stuff so you have it. And that way you'll have it, okay? Thank you. There weren't any questions? Okay. Awesome, awesome. Thank you. You guys take care. I am going to hopefully stop recording. Stop sharing. Swoop. All right.
You could, choice, people have forms on